Reporter. And if you feel there is abuse going on, and that can mean abusing the medication, then we are mandated to report it. In so doing, this is apropos to the slide that is currently on the board behind me. Confidentiality. Are we breaching confidentiality if we call DCFS, Department of Children and Family Services, or DFS, or whatever it's called in the state in which you practice? Remember, what is confidentiality? Confidentiality is the mandate that you not discuss the patient's diagnosis, treatment, information with anyone else without the patient's permission. This is a privilege that the patient owns. The patient owns the right to waive this privilege. We as clinicians do not have the right to waive it. The only time we may divulge this information is, number one, at the patient's request. When it is requested by the patient, we must have a form signed by the patient authorizing us to release that information. Typical forms will explain the reason for the release of it, continuity of care, or it can just say per patient request, and the patient can put on dates from which to which that information may be released, and after that final date, bless you, it may not be released after that. So the patient owns the information. When it comes to issues of abuse, we are allowed to contact Department of Children and Family Services with a suspicion that there's abuse. We don't have to have actual proof. We have to have a reasonable suspicion. It cannot be unreasonable. It has to be a reasonable suspicion. And with regard to a reasonable suspicion, then we cannot be held for having breached confidentiality. Okay, so you may do that. As a mandated reporter, you may do that. Now again, how does this apply? Well, patient presents to your office, and the patient may present to your office and may have a sexually transmitted illness, an STI, or when I was in training it was called an STD, sexually transmitted disease. The individual may have an STI. Depending on the jurisdiction in which you practice, most likely you are mandated to report that to the Department of Public Health. Now, when you report that to the Department of Public Health, you may report that depending on the state, the jurisdiction in which you practice, the county in which you practice. You may just give the initials, or it may just be kept for accounting purposes, or in fact, you may be mandated in confidentiality to give the patient's name, and they may have to do a follow-up to be certain that the patient is treated and that the patient is no longer a danger in the community due to contagion. Now, patient presents, they have an STI. You cannot walk out into the office and say to someone, yikes, I wouldn't sit in that seat because John who's coming out was just there and egad, he has gonorrhea. You cannot do that. That is a breach of confidentiality. That is an egregious HIPAA violation. John, however, can walk out after being diagnosed and say to the person who is seated in the chair where he was sitting, whoa, dude, you're a brave soul. I was just sitting there and I've got gonorrhea. He can do that, okay? You as the physician cannot. And then if the patient gets up out of the chair and says, is that true? Does John have gonorrhea? You have to say, I cannot discuss another patient's diagnosis, okay? Now, there are other issues if all of a sudden that patient and John hook up and then gonorrhea is transmitted to this other patient by an intimate liaison. Now, that may be a whole other issue. However, it is important to be aware of the reporting statutes in the community in which you practice. One of the areas where this becomes key is what I call the YNT letters. YNT letters. YNT, you're going to, this is my own term. You will hear when you are in practice the YNTs regularly. What are those? Patients are going to say to you, Doc, you need to. Doc, you need to write a letter to the judge. Doc, you need to write a letter to the school. Doc, you need to write a letter to my attorney. The answer is no, you don't need to do anything. You probably need to go home and take a nap. However, when it comes to these YNT letters, what I do is the following. When patients ask me, Dr. G, would you please send a letter to the judge, explain to the judge what's going on? sending gratuitous letters to schools, sending gratuitous letters to judges, sending gratuitous letters to attorneys, not always a good idea. Instead, if an attorney needs a letter from you, it's important for the patient to go back to the attorney and say, would you please fax a request to Dr. Goldman for information? And then you have the attorney send you a letter that is very specific in what it asks. And then you get a release from the patient allowing you to write a letter to that attorney for that specific information. An easier way to handle it is this. When patients come to me and ask me to write one of these letters, instead what I do is I sit down and I write a letter to the patient. And I put the dates, and then I put at the letterhead John Doe, and John Doe's street address, and John Doe's state address and zip code. And I put, Dear Mr. Doe, per your request on this date for your diagnosis and treatment approach, I am listing it here. Your diagnosis is major depressive disorder, recurrent, most recent episode severe. Our treatment approach is utilizing serotonin selective reuptake inhibitor medication, the following medication X at this dose, and we have been utilizing this medication for the past 3 months. Sign it, and then what you do is you make a copy, and you note that the patient was given the letter on this date. You put the copy into the chart, and you give the patient the letter. All it is a communication between you and your patient. And it is merely documenting what you and your patient already know, your patient's diagnosis and your patient's treatment. Now, the patient is in possession of that letter. Now, if the patient seeks to waive his or her right to confidentiality by giving this letter to his or her attorney, or to give this letter to the school, or to give this letter to a neighbor, or to hand this letter to a judge, that's fine. That patient then is choosing to waive the right of confidentiality because that letter was hand-given to the patient and it is addressed to the patient. And that is the patient's responsibility. So now you are not breaching the patient's confidentiality. You have not sent a letter without a release. Yes?
In theory, couldn't I just write, Dear John Doe, on the front of their case, and sign the bottom of their file, and then sign the bottom of their file with love, your whoever, doctor, whoever, and just hand the case to them with the same principle, like communication, communicating their file to them?
Okay, now, yes, and in fact, we'll get to this. However, the file, the chart, it is a legal document. And the patient now under HIPAA has the right. Prior to HIPAA, please don't hold me to this, however, I think with 35 states had statutes with regard to patient access to their medical records. 35 states, it was either 21 or 35. Please don't hold me to it. It is in your handout, and I have to go back for the update prior to HIPAA. There were state statutes that stated that patients have access to their charts. Also keep in mind that when a patient has access to his or her chart, now under HIPAA, all patients have access to their charts. What they have access to is to actually see the chart and read the chart. They cannot then take the chart, put it under their arm, and leave your office. They are entitled to a copy of their chart. And if they request a copy of their chart, you are mandated by law to make a photocopy of their chart. Now, in so doing, states also have chart copying statutes that tell you what you may charge for copying their chart. And it is mandated by law how much you may charge per page. And it is based on the first X number of pages, a certain amount per page, the next X number of pages, a certain amount per page, and so forth. And there is, in fact, another charge that may be added that is a quote-unquote handling charge. It's mandated exactly how much you may charge. Now, when patients present and they want to review their chart, they can't, it's not Burger King, they can't have it their way from this perspective. They can't walk in at 9 in the morning and say, I'm here and I demand to see my chart. They have to give you reasonable notice. And you may say, you may even put up a notice in your office, you may even say, patients, based under the HIPAA law, patients have a right to see their chart. We request 48-hour notice to have the chart available for review. You may also, and it is prudent, have a staff member with the patient when he or she is reviewing his or her chart. Because what you don't want to have happening is have a patient tear pages out of the chart, fold them up, put them in their pocket, and walk out the door. Nor do you want patients coming in with a heavy-duty marker, a Sharpie or whatever marker they have, lining out things, and now you've lost that information. What you most prudently do is you give them a pad, and you say, if you're not comfortable with something that's in the chart, please put on the top of the page of the pad what page it is and what your opinion is about that, and we'll add it to your chart. Put the date and the time, sign it, we'll add it to the chart. It now will become part of the chart, and you have the right to dispute what's in it. In fact, I don't know if you remember, there was a Seinfeld show where Elaine was trying to get her chart, and the chart was being kept from her. Can't keep the chart from a patient. However, you can have someone present when they're going through it, and there has to be a process whereby they may addend and amend their chart by putting in sheets that give a different perspective from them. Now, if they want a copy of their chart, we make a copy of it for them. You may say to a patient, you may say to them, if instead of me writing a letter, if you'd like a copy of the chart, we'll get you a copy of the chart. Here's what it costs, and we'll give you that copy, and it's yours to do whatever you want. Yes, you can do that. Yes, you can. Writing letters is time-consuming. It is. One may bill for that as well. You can bill for the letter writing, and if a patient really wants it, one of the ways to do it. In psychiatry, we have the advantage. We have longer appointments typically for patients than what we see in traditional family practice or internal medicine. And so in my private practice, I do an hour-long session, and my hours are a 60-minute hour. And so what I may say to a patient comes in, we're doing psychotherapy, patient says, you know, doc, I sure need a letter for XYZ. I tell them, give me 10 minutes during the session. I go and I have a room next to my therapy room where I have a computer and a printer, and I type up the letter, and I come back in, and I hand it to them, and I say, please, let's look over this. Let's see if this is exactly what you had in mind. And they say, doc, this is great. I take it, I sign it, make a copy of it, maybe 2 copies, give them the original and a copy, and I keep a copy, and then they have it to do as they please. And I do that during the session because it's something we'll talk about. It's a therapeutic issue, and it's all included during their session. So again, you know, I will do that for patients. I write letters at night, and I will do that for patients as well. Does this help? Does this make sense? Yes. Again, the key is, who owns the chart? The practice owns the chart. Who owns the information inside? The patient. So the patient is entitled to a copy of it. Now all of this takes on an entirely different flavor with electronic medical records. With an electronic medical record now, patient wants to see his or her chart, you set them up at a computer terminal and they can go through and read their chart. Now if they want to make any addenda, any changes, then you can have them write down changes, and then you can take it from there. And again, how that gets added into the medical chart, you may make provisions for patient addenda to medical chart, and then they can add those in. And in giving patients a copy of their medical chart with an electronic medical record, there are several approaches, one of which is printing it off onto hard copy and giving them the hard copy. I have to tell you, I'm not sure about this. A patient may request a disc of their medical record, and that may be an option as well. However, if one is going to do that, it is prudent for one to do it so that it cannot be overwritten, so that it is on a disc, that it is read-only, if you're able to do that, to protect the information and to keep it from being modified. Okay, that's important. It's a legal document. And while electronic medical records sound great, they are, the dilemma is people still hack into computer systems, and so we don't know who may get access to it, and computer systems go down. And so when a patient presents for care and the computer system is down, whoa, dude, that makes it very difficult to access information. So again, these are issues that have to be worked through. Any questions on that? I was asked earlier about pharmacies. What do we do when a pharmacy calls? And again, we are teamed with the pharmacy. They're part of the team of treating our patient. That brings us to the next issue of the learned intermediary. What is the learned intermediary doctrine? That is this. We as physicians are the intermediary between the pharmaceutical companies that produce the medications, the pharmaceutical industry that produces medical devices, and our patients. Our role with patients is to explain risks, side effects, benefits of medication that are provided to us by the pharmaceutical industry. And or for those of you that do surgery, the discussion of risk, side effects, and benefits of different medical devices and treatment approaches in surgery. We are the learned intermediary. What this means is the duty to warn the patient is ours. Because the duty is ours, what you will find is you will receive letters from pharmaceutical companies on a fairly regular basis from different companies at different times with new warnings about their medications. When you receive these letters, it is important to read them and then to incorporate the new information into your risk, side effect, benefit warning to patients when you are obtaining informed consent. Now, with this being the case, it's important to note that in obtaining informed consent, we will go over this again when we actually do the full lecture on informed consent. When it comes to informed consent, who is to deliver the speech on informed consent? Who is to obtain the informed consent? You, the clinician. Can you delegate that responsibility to someone else? No, legally no. You as the physician are the one who must obtain the informed consent. Is this delegated regularly? Yes, it is. I remember as an intern, I would obtain informed consent before surgery. I remember as an intern, I would obtain informed consent before certain procedures were performed and medications prescribed. However, it is still important, ultimately from a legal perspective, the attending physician is held to the standard, bless you, of obtaining the informed consent. That is the individual who has the responsibility, the person who is actually prescribing the medication and signing the prescription. It is not the hospital, it is not the pharmacist, it is you, the physician. Now, should the pharmacist intervene and modify what is being said, then that may change for whom the responsibility rests and on whom. However, barring someone else intervening, you are the learned intermediary. You are the one who must obtain the informed consent and give the information with regard to risks, side effects, and benefits. Now we're talking about issues of malpractice. Now remember, we talked about the American jurisprudential system is based upon this concept of fairness, equity. We are an adversarial system that is friendly because we provide for discovery. And at the foundation of our system, you are innocent until proven guilty. Yes. Remember I said there are two instances where you are guilty until proven innocent? One of them is res ipsa loquitur, and the other I said was tax court. Okay, in tax court, you have to go in and prove that you didn't do anything wrong. Res ipsa loquitur, the thing speaks for itself. What does that mean? This is a type of malpractice action that has components that differ from the traditional malpractice action. Remember, in a malpractice action, we have the 4 Ds in the traditional malpractice action. Duty, was there a dereliction of duty? Was it negligent? Was the negligent dereliction of duty the direct proximate cause of the damages that occurred? In a res ipsa loquitur situation, we have the patient who typically is not aware of what happened. Because the patient is not aware of what happened, The patient does not have the facts to be able to deal with the situation in a usual and customary approach. I'll explain this in greater detail with an example momentarily. In a res ipsa loquitur situation, no expert is needed to establish the duty of care. There's no need to prove, bless you, dereliction of duty or proximate cause. And the burden of proof shifts from the plaintiff to the defendant. What am I talking about? Res ipsa loquitur. Airplanes are supposed to fly, not fall out of the sky. When a plane crashes, individuals are injured. Oftentimes that's res ipsa loquitur. The airline is held liable until they can prove that there was no error on their part. Res ipsa loquitur. An individual has surgery. The individual still has abdominal pain. The individual goes back to the doctor, an x-ray is taken, a little line is seen, and lo and behold, a sponge was left inside the abdominal cavity. That's res ipsa loquitur. The patient has no knowledge of what happened. The patient was anesthetized. So now the burden of proof shifts, because sponges are not supposed to be left in abdomen, nor are forceps, and these cases do happen. Case in point, interesting. I am on a van, a livery service van, being driven from Springfield to St. Louis, long ago in a galaxy far away. I was going to catch an airplane in St. Louis, didn't want to leave my own car, so I went via this livery service. And while I was there was another passenger in the vehicle sitting next to me who was also going to the St. Louis airport. And I will not, again, this was not my patient, so I'm not violating HIPAA. However, for the sake of whatever thin thread of confidentiality may exist, I won't even tell you the gender of the individual. However, we were talking. And in that process, the individual asked what I did, and it came out that I was an attorney. That I was a physician. And the patient and I were talking, and the patient said, oh, the patient recently had surgery. And it was the second surgery. And I said, oh, really? And I didn't probe. Of course, being a psychiatrist, I did a mental status exam. However, I then found out from the patient had had abdominal surgery, and then the patient still had pain. And the patient went back to the surgeon, and the patient said, I'm still having this pain. And the surgeon said, wow, you shouldn't still be having pain. The wound is healing appropriately. The surgery was successful. Everything went well. And so they took another x-ray, and lo and behold, there was a sponge that had been left inside the patient. Those of you who have not participated in surgery yet to date, please note the sponge is not what you use to clean your sink or bathtub. It's not that kind of a sponge. It is a highly absorbent form of fabric. It's a thick, almost like a cottony type fabric, and it has a thin little strip in it that will show up on x-ray, so that you can tell if the sponge has been left inside. And a sponge had been left inside. Again, when we talk about psychiatry, we'll talk about obsessive compulsive disorder, OCD. And we'll talk about attention deficit hyperactivity disorder, ADHD. I move around a lot and lecture in a very animated way, only because I feel that probably 90% of us are here, have made it here successfully because we are driven by our ADHD. And we've been able to succeed because of what bit of OCD we have, to be sure that we checked every bubble on the exam. We went back twice to be sure, yeah, they're in the same order. I did that right. I erased appropriately. I didn't erase too much or not enough. Yes, and that's a good thing. A little bit of OCD is good in the surgical suite, because it's okay to keep asking, please, I'd like a sponge count. How many sponges did we start with? We started with 8, doctor. How many do we have now on the tray? 7. We're missing 1. Let's go through it again. And it's okay to keep doing that. Now, what's interesting about this patient, this individual whom I spoke with in the van, had a second surgery to remove the sponge. I asked the patient casually, I said, wow, did anything come from it? How did you feel about it? And the patient said, oh no, nothing came from it. And the patient said, I really like my physician. And I also know that physicians are human. And physicians, they can make mistakes too. And the physician said, apologize profusely for this error. And the physician said, don't worry. We'll go back in. we'll take it out, and there will be no charge to you for any of it. And this patient, because this patient felt comfortable with their physician, please know, I know how to use appropriate singular grammar. I'm using colloquial there, they, so as not to get into gender. The patient stated that the patient liked their physician, and the patient recognized the humanity of life and practice. And so there was no malpractice suit, which goes to the fact friends don't sue friends. Again, there are boundaries for us as physicians and clinicians with our patients. That being said, sincerity, true concern for our patients, compassion, those will go a long way in protecting you as a clinician from untoward results. Please keep in mind that when you are meeting with a patient, if you sit with a patient for 30 seconds or stand at the door with your hand on the doorknob for 10 minutes, the patient who sits with you for 30 seconds at eye level will feel that you spent more quality time with them than the patient for whom you stood at the door with your hand on the doorknob looking like you were ready to take flight. When you have a contact with a patient, think of the patient as if he or she were a family member. Think of the patient as if it were yourself. What would you want? You would want the clinician to be sitting with you, eye level, talking with you, not talking at you or to you. It's very important. Speaking in language that you understand, and talking with you and listening as well to the questions that are asked and responding to them appropriately. Now, res ipsa loquitur. Again, remember, when the sponge was left inside, the patient doesn't have to put on witnesses, doesn't have to prove anything other than the sponge was left inside. I rest my case. The preponderance of the evidence, the burden of going forward, that's it. All the plaintiff's attorney has to say is, Your Honor, there was a sponge left in my patient. Sponges are not supposed to be left in patients, and we rest our case. Now it's up to the defense to prove that either wasn't the physician's error, that's going to be hard to prove. It's up to the defense to prove the sponge was there for an important reason. Yes, we purposely put the sponge there. We wanted to absorb more. No, it's a res ipsa loquitur. These are very difficult cases. Again, the harm complained of rarely occurs in the absence of negligence. So again, negligence is imputed to this because it happened. The situation is under the complete control of the defendant physician. Patient is not contributorily negligent. The patient didn't contribute to this. You can't argue, oh, the patient hadn't come in for the surgery, this would have never happened. It's the patient's fault. You can't argue that. Okay, there's no contributory negligence, and there's certainly no comparative negligence here. The plaintiff did not contribute, as we just mentioned, and only the defendants have access to the information as to what happened. So you see, now, of course, discovery comes into play, and you're going to access the medical chart, you're going to read, and this becomes a key issue. So the burden of proof shifts to the physician. This is res ipsa loquitur. Now, when we look at malpractice cases, we've been talking about negligence. We've been talking about a duty, and there was a breach, a negligent breach of a duty. That was the direct cause of these damages for duties. Bless you. Now, there are other theories upon which malpractice may lie. And again, that's a legal term, to lie, L-I-E. It doesn't mean not to tell the truth. It means that it is a case may go forward. It is upon this that the facts lie, and it goes forward. And what are these malpractice issues? And we will cover these. We'll go through all of these quickly tomorrow. Abandonment of your patient, battery, Breach of confidentiality, and we'll go through confidentiality in much greater detail. Defamation, failure to obtain informed consent, that's a big one. Failure to report, failure to warn and control, false imprisonment, negligent referrals, strict liability for drugs and medical devices, and vicarious liability. We'll go over vicarious liability also, critical. We'll go over all of these. And we will start that process now. If it's okay, we'll go until about 1/4 till, and then I will do a visual display for us. Does that sound good? Okay, here we go. Abandonment. This is important because this is something that we all truly want to avoid. Abandonment, as an outpatient physician, you are under no obligation to accept any patients you don't want to. Now, that's as an outpatient physician in your own private practice. If you are an outpatient physician in a group or in a medical organization, you may not have strict control over which patients you accept or don't accept, because they will come through a triage center, and then you will go in each day and you will have a schedule established and you will see your patients. And that's if you work as an employee for a large medical group or a hospital group, which most today, medicine is changing, and it's not as common today for an individual to graduate medical school, do an internship and a residency, and then go out and hang out a shingle and start your practice. That's not as common as it once was. More and more medical school graduates and residency graduates and fellowship graduates are going to work as employees for large groups and hospital organizations, and many of you will do that. However, once you have accepted a patient into your practice, once you have established a patient-physician relationship, there is an obligation and a responsibility to be available to your patient. Now, there are ways to handle this. What this means is that should you be out of the office, should you be away to conference, should you be on vacation, should it be after 5 o'clock, your patient has to have access to medical care in an emergency situation. Now, when I completed my training and went out to practice, number one, we all had a pager. I don't know how many individuals have pagers anymore. We all had a pager. I still have my pager. Now everyone has most likely a cell phone or a quote-unquote smartphone and an answering service or some type of system whereby you can be contacted. And after 5 o'clock or on weekends, patients have to be able to access you should there be an emergency that arises. Now, that being said, failure to be available for your patient in time for need may result in a malpractice lawsuit for abandonment. Abandonment means not being available for your patient in an emergency situation when you were needed. Many physicians now will deal with this as follows. When the patient becomes part of their practice, they will say to the patient, after 5 o'clock in the evening and on weekends, should you need medical care or emergent medical care, you are to go to the nearest emergency room and have me contacted by the staff at the emergency room to maintain your continuity of care. I want to know that you're at a safe place, and then I can provide the information for continuity of care for you with whomever is the treating physician at the ER. And you can do that. You can explain that to the patient. You can have that in the paperwork when the patient signs up for your care and your services, and it lists all the patient rights and responsibilities you can put in there for care after 5 o'clock and on weekends and on holidays. Patients are to go to the ER and have me paged. Now, incumbent upon you is to be available to the ER. You have to have a pager or you have to have a phone so that you can be reached. That being said, one of the other options is to have another physician, another clinician who covers for you, and that's very common practice. And practices will do that. When one physician is away at a conference or on vacation, another physician covers for him or her. And when another physician covers for him or her, then that physician will take the calls from your patients and then will deal with their needs and will document that. With that being the case, there will be times when you will receive phone calls after 5 o'clock and you will deal with those. And what does that mean is I have a pager and I have my cell phone. And so I don't have patients call me directly. They call my answering service. My answering service calls me and I call the patient back. And in fact, my cell phone is blocked, so it shows up blocked number because it's prudent, I have found, for patients not to have direct access to me because of my field of practice. It's sometimes not a great idea for them to become inebriated and call me at 3 in the morning as they're leaving the local bar. So again, with that being the case, it's important to be available to your patients and to document your discussions with your patients after hours. I have a pad in my car. I keep a pad with me at all times. I put the time, the date, and how long we talk. I put when the conversation began, when the conversation ended. Cell phones are great for that because cell phones have a timer on it. You can look to see when you started, when you stopped, and that's a good thing. And the reason for that is, heaven forbid there's ever a malpractice action, you want to be able to show exactly how much time you spent on the phone with your patient. We are going to pick up tomorrow. Where we're leaving off here, we will pick up, I believe tomorrow is 2 to 4 because I told you we would do a visual demonstration. And I have a deck of cards. The deck of cards is hopefully as mixed up as I am. I will remove the joker from the deck. I will shuffle the deck, giving it one good shuffle. I am then going to ask, if I may, I have you just say stop at any time?
Stop.
Very good. Please don't let me see the card, but I'm going to have you remove that card, and I will have you hold on to that card if you will. We're going to take the deck. Going to put rubber bands, bless you. I'm going to put rubber bands around it. And if we go a minute or two over, I appreciate your patience. I am now going to hand the deck, if I may, I'm going to hand you the deck, and I'm going to ask you in just a moment to just quickly pick up a section of the cards and look at one card, and then memorize that card. And then let the cards drop back down. Just lift up, look at a card, memorize it, got it? And then I'll have you hand the deck to someone else. Very good. I'm going to ask you, please, to just, holding it flat in your hand, yes, pick up and look at any card you want, memorize the card, and then close the packet and hand it to someone else. And then, if you will, just kind of keep your hand up so I know you've looked at a card. Yes, just look. And I'll have you hold your hand up so I know. And then hand the deck back to someone else. And so we'll look at 4 cards, and I'll have you please take a peek and then let it down. And I'll take the deck back. And I'm going to ask 4 of you to stand up if you will. Those of you who looked at a card, please, if you will, stand up. My first levitation act of the day. Very good. Okay, we have 4. I'm going to ask you all please to concentrate, and you're holding a card, am I right? So I'm going to ask you please to stand up with the card you're holding. Take the rubber bands from the deck. Putting the deck away, so you cannot observe it. And then I'm going to ask you all, if you will, to please concentrate on your card. I'm going to ask you please to picture your card in your mind's eye. I want you to concentrate. I share with you that I once had a job at an orange juice factory. I lost it because I couldn't concentrate. I'm getting an impression. I'm getting 4 pictures. I'm going to call off the 4 pictures. Please remain standing. And if in fact I called off your card, when I'm done, then I'll have you all sit down. If I've called your card, don't sit down yet. I'm getting a picture. I'm getting a picture of a 3 of clubs. I'm getting a picture of a queen of hearts. I'm getting a picture of an 8 of spades. I'm getting a picture of a 5 of diamonds. If I called off your card, please sit down. Thank you. One card. I didn't call off, did I? And you're holding that card. And this brings me to a key issue. And we will talk tomorrow in greater detail about malpractice insurance. As a magician, I carry insurance as well. And this is magician's insurance policy. And it is important. The most common contract entered into in the United States is the insurance contract. The least often read document in the United States is the insurance contract. It is imperative that you read the conditions of your policy. So when you obtain your malpractice insurance policy, please read it. It is complex. It is important to know what's in it. And in fact, the first condition of our policy here is all parties involved must be dealing with a full debt. I trust we are. And in fact, my policy hopefully covers my practice completely because you selected a card completely at random from a shuffled deck. Is that correct? You're holding that card. And in fact, how did my insurance policy do? Will you please show the card? What is your card?
Looks just like my card.
Excellent. Thank you. I'll see you all tomorrow, 2 o'clock.